Maraming salamat sa pagpapakilala. Magandang umaga po sa inyong lahat. 45 minuto lamang ang binigay sa akin dito sa lecture na aking ibibigay sa inyong umagang ito, which I usually deliver in 2 hours during the mandatory continuing legal education. So bear with me. I'll do this fast so we can also have an open forum later on. Before I deliver the lecture, Lessons Learned 24 years after UDHA, let me read a message which I received from my regular texter. He said, "We cannot erase the past. We must let it go. We cannot change yesterday. We must accept the lessons learned. We cannot stop time. We must abide by its demands. We cannot predict tomorrow. We must allow God to take control. Let love, faith, and hope be the answer to the mysteries of life." May this serve as an inspiration to all of us as I delve into this topic, Lessons Learned 24 years after UDHA. UDHA, of course, refers to the Urban Development and Housing Act of 1992. This is a law that I authored when I was a senator. And I feel very close to this piece of legislation. After all, I had been pilloried, attacked, lambasted by those who did not understand what the law is all about. But this law, Republic Act 7279, that's the number of the law, provides the blueprint, the master plan, the way to go on how to develop our cities and all the urban areas of the country. The blueprint, the master plan, which includes the policies, strategy, and procedures on how, say, Manila City, Quezon City, Pasay City, Cebu City, Davao City, and all the other cities should be developed. So when you talk about urban development or planning in the Philippines, this is the law that you must go to. This contains almost everything under the sun when you are dreaming of developing or renewing our cities. 24 years had passed since its effectivity, but not much has changed with regards to our cities. With regards to the 143 cities that we have, and all the municipalities that are considered urban areas with a population density of 500 persons per square kilometer. But in developing cities or renewing cities, making them livable and sustainable, the law makes it very, very clear that you cannot have developed or sustained cities by excluding the poor. The poor, or what the Constitution refers to as underprivileged and homeless citizens, must be part of the development. Most preferably, not shooing them away of the cities, but making them sure that when cities are developed, there should always be provision for housing for these underprivileged and homeless citizens. If there is growth in the city, it must be inclusive. The rich and the poor must stay together in developed and sustainable cities. Had UDHA been implemented fully, our cities would have been better organized. Had UDHA been implemented fully, our cities would have been more livable, and the homeless poor accommodated and sheltered within the city, not to be thrown away to the suburbs or to far-flung and remote areas away from their source of livelihood or income. These were the sites of cities in 1992. Yan. These are the sites. Take a look. In 1992, when I crafted, it's okay, and held public hearings on the proposed UDHA, these were among the sites. These are the sites. Well, some of these sites no longer exist. But by and large, however, they are still very much visible, even in our capital of the country, the city of Manila, and even within this city where we are holding this event, there are still pockets and big colonies of informal settlers or squatters. With the exception perhaps of the city of Marikina. By the way, examples of livable cities to dream the impossible dream and to reach the unreachable star, as the song goes. So, Singapore, Portland City, Vancouver, Sydney, Stockholm, in Sweden, but nowhere in the list of top livable cities or any cities in my home country, the Philippines. Republic Act 7279 was signed by President Aquino in March 1992. It's a forward-looking law to head off problems of rapid urbanization and urban decay and each housing for the poor at the time. My friends, and this will be attested to by my good friends Popoy, Roque, who will be the moderator, and Commissioner Linda Hornilla, and environmental planner Cora Cruz. In 1992, out of 65 million plus Filipinos, 50.8% were in the urban areas. In 2012, 66.4% of Filipinos are living in cities. Now it's 2016. If the trend continues, most of our people will be living in urban areas. In the world, in 2013, 60% of the people in the world will be living in urban areas. Okay. The statistics that were shown to us in 1991, while Commissioner Linda Hornilla and I were working on this, because Commissioner Linda Hornilla, who will be discussing the National Framework Development Plan, which is part and parcel of the Urban Development and Housing Act. These statistics were practically the same. The housing backlog was pegged at about 3.9 million housing units. The number will exacerbate to 6,546,000 by 2030 if no special housing program is created. But as far as those who can afford and those who need assistance or subsidized housing, the figure in 1992, which was about 3.9, is still the same as 3.9 in today's statistics, making me wonder whether our gathering of data or the numbers that we use is really accurate or not. And this is a challenge to all of us, to all of you, environmental and urban planners, to get the numbers correct. You cannot plan well if your number or data are guesstimates. And I am afraid our numbers are guesstimates even up to this point in time after 24 years of UDHA. The right to housing is a universal human right. It's found in our international treaties signed by us. In the Universal Declaration of Human Rights, the right to housing has been recognized, and we are signatory to this international treaty. Another treaty is International Covenant on Economic, Social, and Cultural Rights, the right to housing, together with the right to adequate food and clothing, had been recognized as part of human rights. So these were the basis of what we did when we were, the basis of the law, when we crafted it in 1992. In our Constitution, this is the basis, which basically reiterates our commitment under international law. The 1987 Constitution states that the state shall provide or undertake a continuing program of urban land reform and housing. There you are, urban land reform and housing. That's a commitment of the state for the underprivileged and homeless citizens. This is important because urban planners, environmental planners, local officials, and other allied professionals, they should have a clear understanding of where Urban Development and Housing Act of 1992 has been derived. So let me go back to this. The state shall by law and for the common good undertake in cooperation with the private sector. So the key words are the state, for the common good, together with the private sector, undertake a continuing program of urban land reform and housing, which will make available at affordable cost decent housing and basic services to underprivileged and homeless citizens in urban centers and resettlement areas. By law, the state shall by law. There you are. When I was a senator, it was my duty as chairman of the Senate Committee on Housing, Urban Development, and Resettlement to craft the law. And in crafting this law, we should also make sure that the state shall promote adequate employment opportunities to such citizens. In the implementation of such program, the state shall respect the rights of small property owners. So in developing the urban areas and providing housing program for the poor, the state shall ensure that there will be adequate employment opportunities to the poor and to the homeless, and that the rights of small property owners are respected. What are the small property owners? Those who have 800 square meters in the rural areas and those who have 300 square meters in the urban areas. Urban or rural poor dwellers shall not be evicted, nor their dwellings demolished, Please take note of this because Lina Law has, well, that's how the law has been identified. It was the critics, the critics of the law called it the Lina Law after criticizing me, so that the negative will stick to me and hopefully it will not stick to you after this lecture. Urban or rural poor dwellers shall not be evicted nor their dwellings demolished except in accordance with law and in a just and humane manner. This means that eviction or demolition of shanties or dwellings or poor dwellers is not barred. It's not prohibited. It can be allowed, but there has to be a law that will determine the procedures or the guidelines in the eviction and demolition. And it must be in a just and humane manner. Makataong pag-aalis sa mga tao na ang mga bahay ay wawasakin sapagkat sila ay kinakalampalisin. Another principle that must be clear, which the Constitution upholds and promotes, is this: no resettlement of urban or rural dwellers shall be undertaken without adequate consultation with them and the communities where they are to be relocated. My friends, so paalisin natin, allowed yung mga informal settlers, allowed yon in a just and humane manner, and I will explicitate on what is just and humane manner of demolition or eviction. But before they are resettled or relocated, there must be adequate consultation with them. Consultation means hearing them out before they are resettled. And what time, where they should be consulted, and not only must the informal settlers or squatters be consulted, the communities where they are to be relocated must also be consulted. So there are 2 points of consultation: the relocatees and the communities where they are to be relocated. I did not invent this. This is in the Constitution. So, Republic Act 72-79 is that law which the Constitution mandates Congress to pass with regards to urban land reform and housing, a mandate of the Constitution which government must undertake. So, the Urban Development and Housing Program shall, these are the key result areas, KRAs, of the Urban Development and Housing Program. Uplift the conditions of the underprivileged and homeless citizens in urban areas and resettlement areas by making available to them decent housing at affordable cost, basic services, and employment opportunities. Please take note of the word affordable. The cost of the land, the cost of the housing unit, or the cost of the house or the rent, that must be affordable given the economic situation of the underprivileged and homeless citizens. Who are the underprivileged and homeless citizens? They are those, according to NEDA, whose income is below the poverty threshold. So the poverty line moves up or moves down depending on the economic situation of the country. Provide for rational use and development of urban land in order to bring about the following. This is very important for all of you, urban planners and government officials. There should be rational use and development of urban land in order to bring about the following. Equitable utilization of residential lands in urban and urbanizable areas with particular attention to the needs and requirements of the poor. And not merely on the basis of market forces. Again, this is a very important policy consideration. when you plan cities and provide for the housing needs of the underprivileged and homeless. When you use market forces when planning for the housing of the underprivileged and homeless, then the natural result is to move away or throw out the poor and the homeless to far away and remote areas because they will not be able to afford the cost of land. When there's development in the city, the cost of land is very high. Example, the National Government Center, the Trinoma area, that's a government land. But because the price of land there has become very high, then market forces were used as the basis on where to put the housing for the poor, the area which, according to the UDHA, should have been reserved for housing for the underprivileged and homeless, was sold to the private sector because the land would fetch a higher price. If that is our thinking, if government planners, private or public planners, will use market forces as the basis for planning a city, then you will not be able to provide housing for the poor because they will not be able to afford the cost of the housing unit. Gets nyo? This is very important. According to Architect June Palafox in Massachusetts, there is an anti-snub law. You cannot be snub and consider the poor as not being able to access the market because the housing market fetches high price per unit. So the housing program for the poor should be outside from the city. Snub. So there is an anti-snub law in Massachusetts, but Republic Act 7279 came out earlier than the Massachusetts anti-snub law. Palakpak naman kayo ng kaunti doon. So another policy. In short, the development must consider these policies as enunciated in the UDHA. Optimization of the use and productivity of land and other resources. Self-explanatory. Development of urban areas conducive to commercial and industrial activities which can generate more economic opportunities for the people. Reduction in urban dysfunctions, particularly those that adversely affect public health, safety, and ecology. Number 5, access to land and housing by the underprivileged and homeless citizens. Adopt workable policies to regulate and direct urban growth and expansion towards a dispersed urban net and more balanced urban-rural interdependence. Very academic, no? You learned this when in your in the school in the urban planning. All of these nice words, they're also here in the policies as enunciated in the law. Provide for an equitable land tenure system that shall guarantee security of tenure to program beneficiaries, meaning the underprivileged and homeless citizens, but shall respect the rights of small property owners and ensure the payment of just compensation. Encourage more effective people's participation in the urban development process, meaning people should not just be bystanders. They should take part in the decision-making process. Improve the capability of local government units in undertaking urban development and housing programs and projects because local governments are the ones principally in charge of developing cities and providing affordable housing for the poor. Let me stress that. You can create all the departments in the national level and bolster the powers of the HUDCC and all those national agencies. But if the local government units are not empowered, if they are not capacitated, if their hearts are not in the right place, and they have their own agenda to line their pockets, unlike Mayor June Diamante, whose Tuburan will become a city soon, and he will make sure that UDHA is implemented in Tuburan, Cebu. Then all of these nice words, high-polluting words, will not come into play and will not be realized. Affordable housing, I'll go through this. Definition of terms. Affordable cost refers to the most reasonable price of land and shelter based on the needs and financial capability of the program beneficiaries and appropriate financing schemes. Consultation, I already explained, it doesn't mean consent. When you consult the informal settlers or those whose shanties or dwellings shall be demolished and the informal settlers evicted, they should be consulted, but it doesn't mean consent. Consultation does not mean consent. To hear them out, what will be the best time, what would be the best place, or to give them the right of first refusal if they want to buy the land which they are squatting on, that will be part of the consultation process. Misconception. Some people misinterpret the law that when you use the word consultation, it means consent. It does not. It is not that. It doesn't mean consent. Land use plan. I'm sure Commissioner Hornilla will elaborate more on this. But land use plan refers to the rational approach of allocating available resources as equitably as possible among competing user groups for different functions consistent with the development plan of the area and the program under this act. Under the local government code, ladies and gentlemen, each local government unit, whether city or municipality, must have their CLUP, the Comprehensive Land Use Plan, where the various uses of land are demarcated. You'll have residential, commercial, industrial, agricultural, forest land, where you will put your forest parks, your open spaces, how you plan your roads, so that you can anticipate the future needs of your city or municipality. Professional squatters. This word will continue, phrases will continue to haunt you, but this is for the first time, UDHA, that's the only law that defines what professional squatter is. There are three kinds of professional squatters. Individuals or groups, number one, who occupy lands without the express consent of the landowner and who have sufficient income for legitimate housing. Ang ibig sabihin nito, ito yung mga mandurugas. Mayaman na, nag-i-squat pa without the consent of the owners. Number two, the term also applied to persons who have previously been awarded home lots or housing units by the government but who sold, leased, or transferred the same to settle illegally in the same place or in another urban area. The problem is, the National Housing Authority has not used the technology needed to track down all the people who have been given housing assistance by the government. So kailangan siguro the National Housing Agencies should include this in their planning to be able to track down all the people who have been given housing units by the government. And number three, the intruders. The non-bona fide occupants and intruders of lands reserved for socialized housing. The term shall not apply to individuals or groups who simply rent a housing from professional squatters or squatting syndicates. Squatting syndicates are those who rent out housing units in squatter areas. Yun ang squatting syndicates. Okay, we will... I already mentioned this. Small property owners, the rights should be respected. When you set aside areas for socialized housing, you can expropriate, government can expropriate lands for socialized housing, but in so expropriating, the small property owners, their land cannot be expropriated. 300 square meter in highly urbanized cities and 800 square meters in other urban areas. Underprivileged and homeless citizens, I already explained to you who are the program beneficiaries of the Urban Development and Housing Act. What is covered in the Urban Development and Housing Act of 1992? Meaning, what are those areas that must be developed using the policies enunciated in the law? The program shall cover all lands in urban and urbanizable areas, and in other areas that may be identified by the local government units as suitable for socialized housing. Exempted from the coverage of the Act, those under the Comprehensive Agrarian Reform Law, those actually used for national defense and security of the state, those used reserved or otherwise set aside for government offices, whether owned by national government and instrumentalities. So there are exceptions. Those used or set aside for parks, reserves for flora and fauna, forests and watersheds, and other areas necessary to maintain ecological balance or environmental protection. Those actually and primarily used for religious, charitable, or educational purposes, cultural and historical sites, hospitals and health centers, and cemeteries or memorial parks. So, ladies and gentlemen, here is a city, for example, you want to develop it, you want to renew it, but in so doing, you have to make sure you have provision for housing for the underprivileged and homeless citizens. And in developing the city, you have to observe the policy guidelines enunciated in the law, which are in accordance with the Constitution. And there are areas that you cannot include in the housing for the underprivileged and homeless citizens. The law says that there shall be a national urban development and housing framework to be formulated by the HULRB. That's why Commissioner Hornilla is here. She will elaborate on this. Under the direction of the HUDCC, in coordination with all local government units and other concerned public and private sectors. The framework shall refer to the comprehensive plan for urban and urbanizable areas aimed at achieving the objectives of the program. So, the local governments have their own land use plans. So, what the HULRB and the HUDCC will do is to collate all of this, provide for a rational framework where the national roads will pass, where the railroads shall pass, where the ports shall be located. There shall be a national framework plan and housing plan. And that's the work of the HULRB under HUDCC. But very important is the comprehensive land use plans of the various local government units, particularly the city and municipal governments. So, you're now planning the city, or replanning the city, or renewing the city. Who is the primary actor in this endeavor? The local government units, principally the city and municipal governments. And that must be emphasized. We should not look towards the national government for the main action. The national government only performs a supporting role. The primary actors are the local governments, the cities and municipalities. And these local governments must conduct an inventory of all kinds and improvements on their land within the respective localities. The inventory shall include the following: residential lands, government-owned lands, whether owned by the national government or any of its subdivisions, unregistered or abandoned and idle lands, and other lands. inventory of lands that should be done by the local governments. Once the inventory is completed, the local governments shall now identify lands for socialized housing and resettlement areas for the immediate and future needs of the underprivileged and homeless in the urban areas, taking into consideration the degree of availability of basic services and facilities, their accessibility and proximity of job sites and other economic opportunities, and the actual number of registered beneficiaries. It is important that the land use plan is in place. In the land use plan, there will be residential areas so identified. And in the residential areas so identified, the local governments must delineate or identify the areas that will be used for socialized housing, or those programs, housing programs or projects undertaken by the government in cooperation with the private sector for the underprivileged and homeless citizens. So the assumption is there is a CLUP, Comprehensive Land Use Plan, by the local government units, and from there, you can identify the residential areas that you will demarcate, and within the residential areas, you must identify the ones that will be utilized for socialized housing. For the sake of belaboring the point, in the CLUP, kompleto yung development mo ng cities. Ecological balance, air pollution control, traffic flow, movements of people, all of that will be part of your overall plan. But the focus that must not be set aside is socialized housing for the poor. Okay? So you identify the government-owned lands in the inventory which have not been used for the purpose for which they have been reserved or set aside for the past 10 years from the effectivity of this act and identified as suitable for socialized housing shall immediately be transferred to the NHA, subject to the approval of the President of the Philippines or by the LGU concerned, as the case may be, for proper disposition. An important concept, let's go back to identification of sites for socialized housing. So when you do your planning, it says here that the lands for socialized housing shall take into consideration degree or availability of basic services and facilities. Anong ibig sabihin? Yung i-identify mo na sites for socialized housing must have basic services and facilities like potable water, electricity, access to primary or secondary roads, access to job sites and other economic opportunities. They are people too. If they are to be relocated, if they have to be resettled, make sure that this matter is observed. I understand Senator Ejercito has already filed a bill or moving towards this direction of making sure that the resettlement must be in city to remove any doubt, to remove any confusion, to remove any discretion that the resettlement or relocation area must be within the city. Whether that will be absolute or not, I am not sure. But the direction is to make sure that in developing cities, the poor are always included, not excluded. So we identify sites for socialized housing. Number one to be used, government-owned lands under paragraph B, which have not been used for 10 years from effectivity of this act. The difficulty here is Naka 10 years na nga, 20 years na. Pero, it's still the President who shall approve the utilization of government lands for socialized housing. Should it be mandatory already? I was just asked a while ago, ano ba yung changes na pwedeng gawin sa UDHA? Maybe to tighten this. Make sure that government-owned lands must be utilized if they have not been used for more than 10 years for the purpose they have been reserved, should be allocated for socialized housing. Or there should be very, very strict exceptions. Example, Trinoma, again, that area, the National Government Center. More than 10 years had elapsed from the effectivity of this law, but they have been used for other purposes. Kung hindi na ginamit for the purpose, they should have been assigned by the government, by the President, already for socialized housing. Priorities in the acquisition of land. Ito, importante ito. May Supreme Court decision on this. So, we're still on socialized housing. How do you acquire them? Acquired in the following order. In short, may order ito. Not everything goes. There is an order. Number 1, owned by government. Land owned by government. Number 2, alienable lands. Number 3, unregistered or abandoned and idle lands. Number 4, those within the areas for priority development. Bagong lipunan sites and services. Kakaunti na lang ito. And then lastly is privately owned lands. So to you, urban planners, consultants, environmental planners, in the acquisition of land for socialized housing, private-owned lands shall be the last priority. How do you acquire lands for socialized housing? The following, either through community mortgage. You know community mortgage? That means the occupants of the land, they band together, organize themselves, and they offer to buy the land from the government or from the private owner. Then, it is the government that pays the landowner. If it's private, then the occupants, the members of the Community Mortgage Association, will pay the government. Land swapping, it's self-explanatory. Land assembly or consolidation, land banking, donation to the government, joint venture agreement, negotiated purchase, and expropriation. Important, expropriation. Provided, however, that expropriation shall be resorted to only when other modes of acquisition, please correct that, have been exhausted. So expropriation is the last resort. There are 2 cases that the Supreme Court had decided on this, or three cases, or I think 4 all in all. The city government, I think both of Mandaluyong, Manila, and Cebu, they expropriated private lands to be utilized for socialized housing. The move was opposed, and the Supreme Court said, you, local government, you did not follow Republic Act 7279. You should have exhausted all other modes of acquisition. But they immediately went into expropriation. So, the expropriation was declared null and void by the Supreme Court. Expropriation still of idle lands, they can be expropriated for socialized housing. The disposition of lands for socialized housing, if the land is owned by the national government, it's the NHA that will decide. If the land is owned by the local government, it's the local government that shall decide. Valuation of lands, equitable land valuation guidelines for socialized housing shall be set by the Department of Finance on the basis of market value reflected in the zonal valuation or in its absence on the latest real property tax declaration. Once lands for socialized housing have been identified. They cannot be sold, alienated, conveyed, encumbered, or leased by any beneficiaries as determined by the government agency concerned. So there is a limitation. Nabigyan ka na ng land for socialized housing or housing unit, it cannot no longer be sold or conveyed, except in accordance with guidelines set by the government. Socialized housing. This is the primary strategy in providing shelter for the poor. To be eligible for socialized housing, these are the criteria. Must be a Filipino citizen, must be underprivileged and homeless as defined, must not own any real property, whether in the urban or rural areas, must not be a professional squatter as defined under the law. So you have made an inventory of land for socialized housing. You have determined by how you will acquire the land for socialized housing. Next, after the inventory and acquisition, you have to register the beneficiaries. Who will do the registration? The local government units. When I was asked during the debate in the Senate, Senator Lina, mahirap mag-register, mahirap ma-identify yung mga mahihirap na walang bahay. My immediate answer was, during election time, when you're campaigning, you know everybody in the area. So, how come you cannot list down and register the beneficiaries who shall be provided socialized housing? So, or this can be done simultaneously. You're conducting an inventory of lands, identifying lands for socialized housing. You can, at the same time, register the social housing beneficiaries. And this has to be done by the local government units. When I was, by the way, the IRRs of this, implementing rules and regulations, were done quite late, after 3 years of the law. Ang tagal. So I was already governor of Laguna, I think, when the IRRs were formulated. There shall be balanced housing development. This is important for all of you to know. When undertaking subdivision projects, there is a requirement to develop an area for socialized housing equivalent to at least 20% of the total subdivision area or total subdivision project cost at the option of the developer within the same city or municipality whenever feasible. This provision is up for amendment because according to observers, medyo nadedengoy ang mga mahihirap. Yung 20% of the subdivision project cost or 20% of the subdivision area, may leeway pa whenever feasible. So yung iba, sa ibang ang development nasa Manila, Metro Manila, yung 20% nandun sa Bicol. So this, I think, should be amended. Ano? In accordance with the standards set by the LURB. May leeway ang developers. So, dapat amyendahan na ito para talagang inclusive ang development, hindi exclusive. Maraming leeway eh. Development of new settlement, pwede siguro yan, as slum upgrading or renewal of areas, meaning yung 20%, pwedeng ganito ang equivalent, no? Participation in the community mortgage program, joint venture, wherever it is. And whatever is the implementation of the 20% balanced housing development, it should be within at least within the city. All right. There are incentives for the NHA when they undertake socialized housing program. That's self-explanatory. Incentives to private sector. This is important for all of you to know. We are encouraging the private sector, remember? Under the Constitution, the state shall, for the common good, undertake in cooperation with the private sector. So, what are the incentives to the private sector to participate in socialized housing? Siguro, kakantahan ko muna kayo para ma-break yung monotony. Palakpak na muna kayo so you wake up a little. Joke lang, hindi ako kakanta. Incentives of private sector. Okay? Reduction and simplification of qualification and accreditation requirements for participating private developers. Ladies and gentlemen, one-stop shop. This leaves much to be desired. Lessons learned, the law is only as good as it is implemented. The law is good, but is it being implemented? Creation of one-stop shop, I already mentioned. Exemption from the payment of the following. Exemption from the payment of the following. Very nice to hear. Music to the ears of the developers who want to participate in socialized housing. But are these being followed? Exemption, project-related income taxes. Project-related income taxes. Socialized housing project, anything about the project should be exempted. Project-related income taxes. In law, when the law is clear, there is no need for interpretation. But the BIR continues to interpret this differently. So the private sector is discouraged from participating. Okay na ako? Last 5 minutes. Capital gains tax on raw lands used for the project. Value-added tax for the project contractor concerned. Transfer tax for both raw completed projects. Donors tax. Ang daming incentives to the private sector. Question, are they being given? Answer. Para kang humatak ng bayawak mula sa lungga. There's a saying in Tagalog. In short, papasok ka sa butas ng karayom bago ka makakuha ng incentives mula sa BIR. Livable cities, sustainable cities, housing for the poor, ano yung basic services sa kanila? Potable water, power electricity, adequate power distribution system, sewerage facilities, and an efficient and adequate solid waste disposal system, access to primary roads and transportation facilities. Question, are they being observed? Answer, no. Lessons learned, a law is only as good as it is implemented. We have to take care of the poor. When we move them out, they should have these basic services because they are human beings and government's responsibility is to help its people. There must be livelihood component and the beneficiaries must participate. There should be consultation with the private sector. There are benefits to be given to those who will be involved in the development of the blighted areas. Okay, in 1 minute, I will summarize urban renewal and resettlement. When you develop cities, there will come a time when you will have to reblock, you have to reorganize the cities, you have to decongest some areas so that there will be roads where fire trucks can go through, where you can put up infrastructure, you can put up utilities. You will have to move people when you renew blighted and slum areas. What do? You will have to demolish. You will have to evict from those areas that will be affected when you renew or improve the blighted or slum areas. There will be professional squatters. What do you do with the professional squatters? You can summarily evict them, ladies and gentlemen. This has been decided by the Supreme Court, upheld by the Supreme Court. After notice, no need for court litigation. you can summarily evict them. It's the local government that will determine. Now, of course, the professional squatters will question. There can be a court case. They can get a TRO. Yun ang problema. But if there is no TRO, the local governments can summarily evict the professional squatters and squatting syndicates. Okay? This is decided in Supreme Court in the case of BCDA, in the Port Bonifacio. Ang ganda daw ng mga bahay, the professional squatters sila. Sabi ng Supreme Court. Okay? And, 1 minute yun. Another 1 minute. Okay. 1 minute. This is very important. I said, in the Constitution, there is no bar against eviction and demolition. So the law, Republic Act 7279 says, eviction and demolition shall be discouraged. Shall be discouraged. But, may be allowed under the following. When persons or entities, in short, when you're evicting those who are in the danger zones, that's allowed. Those living in esteros, riverbanks, railroad, near railroad tracks, on the roads, they can be evicted and their dwellings demolished. No need for court order. When government infrastructure projects with available funding are to be implemented, you can evict. You can demolish dwellings. When there is a court order for eviction, of course, when there is a court order for eviction. But in the execution of eviction or demolition orders, the following shall be mandatory. Ito po, mandatory requirements. Notice, consultation, the presence of local government officials or representatives, identification of all persons taking part in the demolition, execution of eviction during Mondays or Fridays unless consented to by the affected families, no use of heavy equipment unless permanent or concrete materials are involved, proper uniforms for PNP, and, very important, adequate relocation. Adequate relocation. Mandatory. Mandatory. Adequate relocation. Not discretionary. Mandatory. Within 45 days, kung may court order, walang relocation. Within 45 days from final judgment, there is no relocation for those houses to be demolished. The local government shall extend financial assistance in the amount equivalent to the prevailing minimum daily wage multiplied by 60 days. If 60 days had passed, no relocation yet, are the local governments absolved now? They are no longer required to provide relocation? No. No. They still have to provide relocation. Gets nyo? It's a mandatory requirement. A resettlement within 2 years, dapat wala na yung nasa danger areas. 24 years na, wala pa. Nandun pa rin sila. Correct? Okay. At pagka natanggal na sila sa danger areas, no more illegal structures. Has this been followed? Nalinis yung ibang lugar, balik uli. After 1 month, balik uli ang squatter. Community mortgage, I already explained this to you. Organization of beneficiaries. You see, this law is complete. These are related strategies in urban development. There should be promotion of indigenous housing materials, transport system. You see, it is in this law that there must be an effective transport system. There should be a smooth flow of traffic, safety and convenience of travel, all the requirements to make cities livable and sustainable. Ecological balance, population movements. These are part and parcel of urban development, urban-rural interdependence. And of course, the primary in charge is the local governments. National housing agencies, HULRB, NHA, HUDCC, Pag-ibig, all of them, they play a supporting role, providing technical assistance and some funding. Funding, There's in the law how to fund the socialized housing program. By the way, the socialized housing program is not for free. It is only affordable. Another misconception that the socialized housing is for free. Lastly, there can be a socialized housing tax of 1.5% on assessed value of all lands in urban areas. Local governments can impose this. Only Quezon City imposed this. Tapos na TRO pa sila. The city that has the most number of socialized housing projects is Quezon City. Na-TRO sila, and the case is still pending with the Supreme Court. So, ang local officials, kapag hindi nila in-implement ang batas, they can be charged for violating the law. Imprisonment of 6 years and maximum fine of 100,000 pesos or both. So, kung hindi ginagawa ng local officials, you can file a case against them for violation of Republic Act 7279. Therefore, lessons learned. Can I just go through this? Ito na lang. Lessons learned. Palakpak muna ka dyan. Lessons learned. Housing is a function of income. Correct? Amen? Housing is a function of income, which in turn is a function of job or livelihood. Kung wala kang trabaho, wala kang hanap buhay, wala kang income. And this job or livelihood is a function of the economy. Without economic development, jobs and livelihood will be wanting, and productive people can't afford to purchase or build a house. No state can provide free housing for its people. So you have to develop the economy. You cannot you cannot just focus on providing socialized housing because there will always be strugglers in our society. Number two, a law is as good as it is implemented. There lives much to be desired. There is spotty urban development going on in the country. There is urban decay. In fact, urban decay is becoming more and more visible. The quality and capacity of governors, city, and municipal mayors will determine the success or failure of UDHA. Kung dedicated, committed, focused, and local executives, then something will happen. It depends on the leader. Number four, the DILG, supported by the President, backed up by the Ombudsman, can pressure the local chief executives to implement the law, lest they be charged for violations of Republic Act 7279. Number five, and this is the ultimate lesson. The electorate must elect only competent, committed, charismatic, and honest leaders. Everything rises or falls on leadership with political will. Maraming salamat. Magandang umaga sa inyong lahat.